However, there are 3 other statutes that he doesn't mention. Even if it would have been filed in the wrong court under statute 16.421, there are still 3 other statutes that do not provide such a limitation. And as I said, that statute you can transfer. And as a matter of fact, there is also statute 396B that states, if the Superior Court lacks jurisdiction of an appeal or petition, and a court of appeal or Supreme Court would have jurisdiction, the appeal or petition shall be transferred to the court having jurisdiction upon terms as to costs or otherwise as may be just, and proceeded with as if regularly filed in the court having jurisdiction. So based on 396A and B, both statutes, Judge Marginis made a mistake by dismissing the case, and therefore the case needs to be reinstated. The decision should be revoked. The case should be reinstated and should be heard on the merits. Additionally, this case is similar to Roe v. Wade because we have 2 issues. One, of course, Mr. Obama's records, and if this is not reversed, he will be in office for 3.5 more years without knowing that he is a citizen of Indonesia, that this is an important issue that needs to be addressed. But moreover, we will have an election next year in 2014. We will have an election in 2016. Now, situation is even worse than it was when I filed this case, because just recently, California legislature has allowed people who are here even illegally to get driver's licenses. They can easily, as a matter of fact, today with the motor law, they can easily get registered and vote in the state of California, even because they're getting their driver's licenses. So it's extremely important for the issue of invalid voter registrations to be addressed on the merits, and all of the invalid voter registrations to be purged from the voter rolls to make sure that we have clean voter rolls. Not so long ago, media was stating, how come the state of California is so different from all the states in the nation? Because California was the only state that has voted to raise its taxes, where the citizens of California were the only citizens in the nation that voted to raise the taxes. Well, I suspect that we did not vote to raise our own taxes. I personally don't know anybody who wanted to raise his taxes. I do suspect that when we have millions of invalid voter registrations, people who are 150 years old, we have registrations, and argued in my case, where you need to put the birth date, we need to put the state where the person is born. Those were not provided. And as a matter of fact, I have emails from the registrars stating that they instructed their employees to just fill in the blanks. Well, this is falsification of voter rolls. This cannot be done in a state. For example, in Los Angeles County, the registrar told his employees to write US or USA for their state of birth, where this area was blank. What he was supposed to do, he was supposed to send those registrations back to people and make sure that they fill out correct information. Here in Orange County, we had a situation where, again, an email that Mr. Collins personally received and I provided, where the registrar told his employees where there is no birth date to just enter. And that there was one person that they entered in thousands of voter registrations. Well, this is falsification of record. We cannot have it. This is extremely important, and this is yet another reason why this case needs to be brought and decided quickly. Another issue that I wanted to bring is the issue of, actually, I was here 2 years ago, and it was a case of TAITZ v. Dunn. Again, I ran for Secretary of State in 2010. I had over 500,000 votes, and the person who ran against me was a registered Democrat in 2 other states, and he ran here as a Republican. What's important about this case that even though the court decided that he did not commit fraud, they did decide that the court had jurisdiction here in Orange County to rule on the issue of elections fraud and dealt with a statewide election. And that shows yet again, and I provided in my brief the case number, if you want I can provide it again, that in indeed, the cases of statewide elections are heard in different counties, not only in Sacramento County. TAITZ v. Dunn was one of those cases. Next is the issue of the accidental college. What Judge Marginis stated is that not only I was seeking an order from Judge Marginis, an order to release Mr. Obama's redacted registration from accidental college. Because of all of the evidence that we have, I believe that he registered there as a foreign student, as a citizen of Indonesia. And I believe that is the reason why Mr. Obama did not respond, because if he were to respond, he would be under the jurisdiction of the court, and he would have to provide those records. He didn't want to provide it, and custodian of record appeared, and that was attorneys for accidental college. Actually, one of the attorneys who came is a personal friend of Mr. Obama's personal attorney, who I'm facing in another case, where I'm filing a RICO case against Mr. Obama or a number of other people who provided those falsified records. But Judge Marginis stated that not only he refused to allow production of those records, he also issued an order of sanctions of $4,000, stating that I have to pay $4,000 in sanctions because, well, he decided that those records should not be produced. And what is important, that attorneys for accidental college have argued that the subpoena was defective, that they did not have enough time to respond, but they did respond. They filed the response the day of the hearing. I actually did not have their response and couldn't even reply to the response, but they did file a response, and the main statement in their response is that this is a private record of Barack Obama. And it's such an irony that when Barack Obama ran for Senate, he and people associated with him went to Superior Court of California and had the private divorce records of his opponent who ran against him, a Republican who ran against him for Senate, released. They argued that private divorce records should be released, and for that reason his opponent dropped out of the case. But they are arguing that records from accidental college should not be released because it's private. And I believe that Judge Marginis has erred in that he ruled against me, specifically because the information that I was seeking is not private. I was seeking just 4 words from this registration. A, his citizenship. Does it say Indonesian citizenship? And that was important because this was a record after he turned 18 years old. So if after 18 years old he confirmed his Indonesian citizenship, he really cannot be U.S. president. 2, I was seeking information or what was his legal name on those records and his place and date of birth. Now, all of this information, A, is necessary information for the public to know if there is a legitimate president or candidate running for president is legitimate. B, Mr. Obama himself made this information public because he stated time and again in his interviews, I'm an American citizen, I'm not a citizen of Kenya, I'm not a citizen of Indonesia, I'm only an American citizen. My legal last name is Obama, it's not Soetoro, it's not Soebarka, as it is in his other records, and this is my place and date of birth. However, all this information is public. I didn't ask for any information that is private. I only asked for a redacted record, for a small excerpt of the record to verify whether the information that he made public is truthful or whether it was fraudulent information. And even so, it was not private information that I was seeking. And 2, even if it would be private information, the interest of the public greatly outweighs the interest of Mr. Obama in preserving his privacy. Even if it would be private, the public, there is a tremendous public interest and public concern in knowing whether we have a legitimate president or the candidate running for president is legitimate. So that greatly outweighed it. It justified release of a redacted record. Judge Marginis erred and abused his discretion in not only refusing to release this record, and it was only 1 week before the election. We had very little time, but he also made an error issuing sanctions.
You're talking about the primary election at this point?
No, well, I filed this right after the primary election. However, by the time it was heard, it was November 1st. This last hearing was November 1st. Then the general election was November 6th. So we had very little time. So considering that there was so little time, that in spite of being served time and again, Mr. Obama refused to respond, it was legitimate for me to seek release of those records from Occidental College, which is here in California. This court has jurisdiction. It was the proper court, proper place. It was justified to seek it.
Just so you know, I don't interrupt you. You have about 5 minutes left.
So complete my statement by saying we had Watergate. We had Watergate when Richard Nixon lied. When Richard Nixon, right here in California, lost his law license for lying and for obstruction of justice. So this is not something out of the ordinary. Sadly, those things happen time and again. I believe the difference between Watergate and Obama forgery gate is that more people are involved. And if you recall, after Watergate, 30 high-ranking officials of U.S. government went to prison, among them Attorney General of the United States, John Mitchell. And we, the citizens, and I have here a number of citizens actually who were raising money because I was doing this pro bono. They were raising money, $5, $10, to help me pay $4,000 of sanctions that Judge Marginis has assessed, in my opinion, erroneously and wrongfully against me. But we, the citizens, have very limited avenues, particularly Justice Attorney General John Mitchell during Watergate was obstructing justice. Attorney General Eric Holder is obstructing justice. I had cases. I have provided this information to FBI, to Attorney General Eric Holder, and they're refusing to take any action. I have submitted a quo warrant to Eric Holder. He refused to respond. I had a situation where I filed in federal court, and the attorneys, U.S. attorneys, actually the same attorney, Benjamin Wagner, who is now involved in this case against J.P. Morgan, they are suing J.P. Morgan for fraud. He and his deputy attorney made an appearance stating, we are representing the U.S. Congress in this case, and I provided their affidavits where members of U.S. Congress and members of Electoral College stated this is a complete lie. Those attorneys have never provided us any information, and we didn't know about this case. So the public doesn't know, media is not reporting. We have obstruction of justice at the very high levels of the U.S. Department of Justice. So I feel it is extremely important for this case for the sanctions to be reversed, for a decision of Judge Marginis to be reversed, and this case to be reversed. I'm sorry, I'm just trying to see if I missed anything.
Take your time. Take your time. You've done a very, very well organized job without any notes. So
thank you.
Amazing.
Thank you. Do you have any questions for me? Oh, one other thing that I wanted to note, the statute under which Judge Marginis have sanctioned me, $4,000, was statute 1987.2. And this statute states that sanctions can be assessed by a judge if actions by a person who is bringing a motion, in this case motion to release the documents, are in bad faith and oppressive. And there was nothing in what I did that was in bad faith and oppressive. And I provided a number of cases as precedents. Usually they would say it's oppressive when you file multiple subpoenas for multiple documents that are not necessary. That's oppressive. I didn't do it. I asked release of one document, redacted. I wanted just 4 words of one document that were in the interest of justice, that served public interest and greatly outweighed Mr. Obama's expectation of privacy. So there was absolutely nothing oppressive and in bad faith in what I did. So there was no reason for Judge Marginis to sanction me and sanction $4,000. And I believe he did it just to discourage not just me, but any whistleblower like myself, any civil rights attorney like myself, from pursuing justice and doing what you swore me to do, is to uphold the Constitution. Thank you.
Thank you, Ms. TAITZ. The matter is now submitted. As you know, we'll issue a written decision. We do not rule from the bench, so people should know that. But the matter is submitted. Thank you very much.